We are ready.
Okay, please call the case.
Good afternoon, Your Honor. The matter before the court this afternoon is the case entitled State of Vermont v. Timothy Souliere, case number 25 AP 449. Representing the appellant, Timothy Souliere, is attorney James Lamonda. Representing the appellee, the state of Vermont, is attorney Farzana Leyva.
Thanks very much. Good morning, counsel. We'll hear from counsel for the appellant first, of course. Please start for the record by introducing your name and identifying your client.
Yes, thank you, Your Honor. This is James Lamonda, attorney for appellant Timothy Souliere.
Thanks very much.
So, yes, on behalf of Mr. Souliere, he filed this motion for reconsideration as a pro se filing. I am assigned counsel for him in Orleans County, and he has asked the court to issue an order appealing the issuance of bail from Orleans County. And so I do have to state on the record that my last meeting with him, he refused to essentially work with me as part of even the pro se filing. At the end, he included a statement of his desire to have a new attorney. I had only been assigned to him after arraignment. He has submitted pro se filings on his own, asking the court to declare that it was an abuse of discretion for the Orleans County trial court to have issued bail at his arraignment. But have not been able to have even substantive conversations with him myself. He refused to work with me when I was at the facility to meet with him. He's held pretrial on this bail. And so there was the initial arraignment. He issued pro se filings on his own. There was one hearing in Orleans County that I was present for. It was scheduled as a status conference, but when I appeared, the court said it would consider questions of bail, but I was not noticed of that, had not even met with Mr. Souliere after being appointed at that time.
That was the, excuse me, counsel, that was the November hearing you're talking about?
Correct.
Has there been another one since then?
There has not. As part of that, the transcript from that hearing, I think it shows that I had not met with him. I was planning to meet with him shortly after, which I did. And at that point, he essentially, after 15 minutes, walked out of the meeting, said he did not want to work with me. So I've still not had substantive conversations with him.
Okay.
But I did attempt to meet with him.
Okay.
So, yes, he has submitted this filing, I think, pointing out, his prior history, the standards for release pre-trial, and feels that he is not a flight risk, has a long local history. The charge that he faces is a failure to report for registry, but had a temporary residence at a motel in Newport.
He has a failure to appear rather.
The pending charge, I believe, that the court issued bail on is failure to comply with sex offender registry.
All right. I thought I saw that he failed to appear at a hearing in August, but
oh yes, I think that is correct. But then he stated that he had called the court at one point to ask for a hearing, asked when hearing was scheduled. There was some confusion, so he did miss court, but may have appeared himself after rather than being arrested.
okay. All right. Anything else?
There is little more that I can add to the record, Your Honor.
All right. Thanks very much. We'll turn to The state's attorney, please start by introducing yourself and identify your client.
Yes, Farzana Leva for the state of Vermont, and the client is the state, and I'm ready to proceed, Judge.
Thank you. Go ahead, please.
So, Judge, at arraignment, the trial court expressly found that there was a risk of flight based on the nature of the offense, the defendant's pending cases, his potential sentencing exposure, his failure to appear, and very important, his lack of stable address. And the court then went into those statutory factors under 7554 and really asked the defense if he could provide any stable address that would allow for a curfew given the number of cases that he had accumulated over a period of time. He's failing to appear, and it should be noted under docket 25 CR 0287, which is the sex offender registry. There was an arrest warrant due to not being able to find Mr. Souliere. That arrest warrant and case was filed on February 28th of 2025, and he was then arrested on April 10th of 25. During that time, he has then picked up other cases such as stalking. And so the court really went into each of those cases as well as exposure, but more so also discussed the fact that he was homeless. And there was really no way of imposing a condition even for curfew. And so at that point in time, based on the consideration, the court determined that he was a flight risk and couldn't reasonably assure his appearance, and thereby rebutting the statutory presumption identified in State v. Duff. And I have the citation, which is 151 VT 433, 1989. And the court then imposed $5,000 bail, cash or surety, which from the state's perspective is a modest amount compared to the number of pending cases and the seriousness of the offense. And together with a monetary bail, the court had also imposed conditions tailored to identify certain risks. The transcript from the arraignment reflects that the court did not actively act effectively or punitively. Rather, it articulated its reasonings on the record and imposed bail only after concluding that lesser conditions were insufficient. So following the arraignment, the defendant then filed a motion for bail review. In that hearing, the court again considered the relevant statutory framework and made an express finding there has been no change in circumstances since the initial bail determination. What is very evident from defendant's filings is that he is all over the place. But what you can pick up from that filing is that he is addressing or he's asking the court to remove the bail, amongst other things that he talks about in his motion. And so I solely had focused on that aspect. And so the court in the bail review transcript, clearly relied on the fact that there has been no facts to make a change or modify his bail. He presented new information undermining the original 7554 factors analysis, and the state submits that the original bail amount continued to reasonably serve its regulatory purpose. And under these circumstances, the trial court was not required to modify bail. And a bail review motion is not an opportunity to re-argue the original determination absent new facts. And I think what's really important is that the court, during the bail review, had indicated if I could have a stable address, you could have curfew, stable address would ensure at least home detention, none of which the defendant brought any address or stable address forward. From the state's perspective, the bail is not excessive. Defense bail argument being excessive fails as a matter of law. In fact, the offense at issue is a listed offense for which the legislature expressly authorized the imposition of bail. $5,000 amount from the state's perspective is minimal in light of defendants' pending matters. Also that it is a listed offense, and excessive would be obviously over, from the state's perspective. 5,000 is, or cash or surety, is sufficient, and not excessive. The trial court, I think defendant also in his motion indicates that the trial court was to take into consideration his finance, and the state submits that the trial court was not required to make findings regarding the ability to pay, to the extent that the defendant suggests that bail is excessive because of personal, because he can't pay it. The state submits that that argument is foreclosed by State v. Pratt, 2004 VT 282, 2017. In Pratt, this court held that the trial court was not required to find that a defendant has the ability to pay the bail amount set in order for the bail to be supported by the record. The inquiry is whether the amount imposed reasonably serves the purpose identified in section 7554. So here the record supports the determination. The absence of express ability to pay findings does not render the bail excessive or unlawful. And so therefore the trial court's consideration of the defendant's pending cases, sentencing exposure, and nature and circumstances of the offense, the fact that he does not have a stable address, those factors were relevant in assessing whether release on personal recognizance or unsecured bond would reasonably ensure appearance, and here it did not. And so the state submits that the trial court properly applied section 13 VSA 7554, and that the record speaks for itself.
Okay, thank you very much. Counsel, Attorney Lamonda, anything more?
I don't have anything to add to the record, Your